I would like to welcome you all to the Brooklyn and Staten Island first joint event of the year, Brooklyn and Staten Island districts. Um, should I sign a brief guide to employment contracts? So very briefly, before we get started into the presentation, I just want to kind of give a quick background on what NYACP is. We are the largest medical specialty organization in the state. We are advancing the specialty of internal medicine in New York State through education, advocacy, and quality improvement. And we represent over 12,000 internal medicine physicians. I want to give a quick thank you and welcome to our NYACP faculty who helped develop and plan this program. Dr. Todd Simon, fellow of the ACP. He's also the NYACP governor for the Brooklyn, Queens, and Staten Island districts. I would like to thank Ofek High, Dr. Ofek High, fellow of the ACP, and he is the NYACP Brooklyn District Counselor. I would like to thank Dr. Niraj Acharya for landing our speaker for tonight and also just being a great personality. He's the NYACP Brooklyn District President. I would also like to thank Anita Serzin, a fellow of the ACP. She is the Staten Island District Counselor, and Dr. Thomas Gutt, the Staten Island District Counselor, District President, I'm sorry. So now I'm going to turn the floor over to Dr. Acharya so he can introduce our wonderful speaker for tonight.
Thank you very much, Isaiah. It's my pleasure to introduce David Vozza. I know him for a long time, and even after many, many years of knowing him, considering that, he's very nice and very helpful, I doubt his credentials as being a lawyer. If any lawyer I would want on our side, then he is the lawyer. I have a number of physicians who have reached out to him, and he has never said no to anybody. He has dished out a lot of very helpful advice and our experience at the medical society and in a variety of other ways have been nothing but spectacular. So without further ado, here is David Vozza, Esquire. Thank you.
Isaiah and Dr. Acharya, thank you for the introduction. I took a look through some of the participants and the attendees here, and I know several names. I feel like I'm amongst friends, and I'm much more comfortable and happy to see that. But I also had seen that in the marketing materials for tonight's talk, I think that something was transposed from my online bio, which indicated that I'd be speaking about fraud and abuse and criminal matters and so forth. That's not the case, although those are certainly fascinating topics that I'm sure that people want to hear. But today we'll be talking about employment contracts in the healthcare setting. Equally, for me at least, a fascinating discussion. We're not going to go so in depth into the technicalities, but at least have some discussion as to what the general terms are in employment health contracts. And the way that I like to generally do these talks is that please feel free to raise your hand during the talk, and I'm happy to answer questions even during. So Isaiah, again, another technical issue. I see a pop-up that says 7 people waiting in the waiting room. Should I do something with that? You're on mute.
If you could make me host again, that would be great. And I could just start admitting people when they join the waiting room.
Okay.
Made you host so that you could share your screen.
So again, I hate to do this, but I don't know how to make
it. Do you see my face like on your screen?
Yes.
All right, you can click the 3 dots.
Okay.
And then it's
make
just
host.
Yep. Mm-hmm.
Okay, so I did that, guys. Without further ado, okay. So I'm David Vozza. I'm an attorney at the law firm Norris McLaughlin, and we have many different departments at our firm. Outside of even healthcare, we have tax, business, real estate, really any type of area of law. And I happen to be in the healthcare group. I am general counsel to the Medical Society of the State of New York, as well as Kings County, Queens County, Onondaga, and several other upstate counties. And the reason why I say that is I kind of get a unique perspective as to what doctors today are looking for and asking about. I regularly field calls from members, and a lot of the times it is regarding some pretty basic healthcare legal concerns. And one of those basic concerns is review and negotiation of your employment contract. And it's, as you can imagine, a very common issue and a very common question that I get. At some point, you do enough of these where you start realizing that most of the contracts and agreements, although they might look different, all essentially say the same thing. And we all understand now that with the consolidation of medicine, a lot of physicians are now being employed by health systems. And that's made the uniformity of these contracts even more so. So generally, when there are physicians who are asking me to review a an employment agreement from a health system like Northwell or NYU Langone, I'm pretty sure it's going to be the basic contract that they normally give out, and it calls for a much more efficient discussion. One of the reasons why I'm telling you that is that there is no reason for you or any physician out there to get an attorney to review a contract and be told that it's going to cost them, 5,000 more, tens of thousands, whatever it is. I've seen the craziest numbers come out with that. A good healthcare lawyer should know, and I've seen enough employment contracts to be efficient with this. That doesn't mean that you should negotiate or review a contract without an attorney. I would still urge everybody to make sure you lean on your experts, and we'll talk about that in a little bit as well. But I don't think that anybody should think this is reinventing the wheel. This is something that every healthcare attorney should be able to provide proper counsel with in a very efficient manner. Now, usually when I do these talks, I like to just touch upon what happens to be a hot topic in healthcare law. A lot of times that falls outside of the subject matter of the actual talk. And today I do want to do that because I think it's extremely important and something that everybody should be aware of. It does not relate to employment contracts, but again, just very important. For the people here in the room that practice and see Medicare patients, which is probably going to be 100%, or if not very close to 100% of the attendees here, everybody probably has received some sort of audit or chart demand over the course of their career. It might be for one chart, might be for several. Sometimes that results in an overpayment or some sort of further action. But many times, most audits just go away with the provision by Medicare or CMS of what they call educational letter. For the most part in the past, those educational letters have been something that we as healthcare counsel and other trusted advisors have told clients take a close attention to. And for the most part, I think that physicians and healthcare practitioners may or may not have taken that advice. What has happened recently, though, is that we have seen CMS actually revoke the Medicare privileges of doctors or healthcare providers if they can demonstrate that educational letter or that education that was sent to that provider previously was not adhered to. And now, as you can imagine, that's a pretty drastic event to lose your billing privileges from Medicare. Losing your billing privileges from Medicare not only means that you cannot bill for the services that you provide to Medicare patients, but it will always mean, as a matter of course, that you will ultimately be put on the preclusion list, not be able to see patients in the healthcare setting that you're at, and for any of the commercial payers, they will follow suit as well. So again, this is something that is that we're seeing in a more recent time period, and it's creating a lot of havoc, and we're dealing with that a lot. So if anybody receives, obviously, any communications from Medicare, CMS, you'll see the NGS or the CMS symbol on the top of the letter. Please don't disregard it. Read it and implement any remedial measures you need to implement in your practice to avoid CMS coming back through their racks, the audit contractors, from giving them a reason to do anything like that. So again, when it comes to that issue or any issues related to healthcare contracts or any healthcare law issue, please feel free to reach out to the good people over at NYACP or to my firm or any of your trusted advisors to give you advice. You're paying people to get their advice, to lean on your experts in order to do that. Okay, can we go to the next slide?
You're in control of your slides. So you can just click next.
Oh, there you go. Sorry. All right. So for today's talk, we're going to go through the basics and we're going to try to give sort of an overview of what are contained in your employment contracts. We have touched upon before that there are general terms to consider and negotiate. We're going to highlight the critical components that typically appear in the agreements that you get. First and foremost, I think much more important than compensation, although that's easier said than actually done in reality, are quality of life considerations. And we should discuss, and we will discuss, how the different terms of your employment can impact your work-life balance, which again, I just think is in the long run much more important than compensation. I'm going to talk a little bit about what affects your compensation. So understanding and negotiating your RVUs. I'm sure everybody's heard of RVUs. If you haven't, we'll go into that a little bit as well. RVUs are going to be what is going to essentially be the metric utilized by employers to pay you and to evaluate you. It's a very unique type of metric for evaluating an individual's services. It's certainly not something that we have in law, but it's something you need to be aware of. Another very important concept is restrictive covenants, and we'll talk about how that can obviously prevent or prohibit physicians from being able to practice where they want. And what are some different types of negotiation strategies, and we'll go over some tips for that as well.
David, real quick.
Yes.
Your slides don't they aren't like showing on the screen.
Okay.
So I'm gonna just share my screen, and then when you're ready to move on, just let me know so it can make it.
I will.
All right. So can everybody see my screen?
Yes.
Yes.
Yeah, that's much better. Thanks.
Thank you.
Okay, so if you can go to the next slide, please.
No problem.
All right, so again, apologize for the technical difficulties. Hopefully nothing else will happen here, but so the basics. So why do we even need a written contract? Well, as you might imagine, written agreements, they're crucial, and especially in a professional setting. Number one, they provide clarity and certainty. So if there's going to be a period of negotiation regarding terms and obligations of parties, we want to make sure that those negotiations are memorialized in a succinct manner in a written document. That the written document sets out clear terms and conditions of your employment, and that there's a mutual understanding of what the terms are. So in the event that there is a dispute, both sides will have a really good sense as to where each other stood in negotiation. So we can't have that without a written agreement. So in that sense, it provides us with a good sense of legal protection, legal foundation for the employment relationship. It offers protection for both sides, and enforcing the obligations and the terms without that written agreement, it is essentially impossible to do so. Otherwise, you're talking about parole evidence being in a legal term being discussions outside the four corners of a written agreement, which are very difficult to prove. Prevents disputes and lends itself to resolution for disputes. Now, the fact of the matter is, you might not know this, but everybody knows what Stark law and anti-kickback and the different referral regulations are. They generally impose a requirement for physicians that any agreements or third-party agreements be in writing, and that the terms and the terms of the reimbursement for services contained in those agreements are fair market value, and they can't generally deviate or be contingent upon the amount of referrals or patients that you see. The same goes for actual employment agreements. Employment agreements have to be in writing in New York. Okay, and the services, your compensation in them, plus your bonuses and so forth, need to be for fair market value. Now, there are some caveats to that. as you might imagine, there are very some pretty creative bonus structures, which a lot of physicians will find themselves entering into. And those will be or fall into what are called safe harbors for those laws. Again, for tonight's talk, we're not really getting into the ins and outs of Stark and anti-kickback, although if anybody has any questions about that, I'm certainly able to do that. So it's in that sense, written agreements are going to ensure that your employment arrangement, will be in compliance with the applicable laws and regulations. So again, in New York, since we're in sort of a really kind of antiquated state when it comes to regulations, making sure that we have a written agreement is not only essential for your protection, but also lawful. Next slide, please. So how do we negotiate? I can't tell you how many times I have received calls from physicians telling me they've received an offer and that the offer is contingent upon them signing this agreement. And I typically get a statement like, I need to sign this by tomorrow, or can you please just review it really quickly and let me know. I think that's generally borne out by some fear, especially by younger physicians. Nowadays, I even get a lot that younger docs and even still some experienced doctors will not even want the law firm to be essentially public facing or involved or intervening in the negotiations. They feel like it's going to rock the boat a little bit, and they feel like it's going to be viewed by the prospective employer that, hey, why would you get a lawyer? You don't need a lawyer for this. We're all playing nice, and it's just not necessary. And I can't think of this several years ago when I first started hearing this type of thought process. I wouldn't say I was offended by it, but I was a little surprised by it, because as professionals, I think that having attorneys review and enter into or intervene on negotiations for something so important as employment agreements is I think just pretty standard. But the way that the employment and physician employment setting is nowadays, it's become one of a lot more or not less opportunities to pick from. And so I think a lot of the younger doctors are just scared to lose out on opportunities. And we'll talk a little bit more as we go on in the slideshow as to why I think that's not a good approach. I have to remind doctors, especially young docs, that they have value. They went through years and years of education, and it's an education and a skill level that they've attained that only the best of us can attain. So it shouldn't be something that they would be scared to negotiate with. So, but I have now, because so many people have asked, and so many especially younger docs have asked, I will negotiate for them sort of in secret or in the background. It makes for a little bit of a difficult scenario, but it's certainly something that we're doing. And to be quite honest with you, I've heard and I've heard attorneys over at in the legal departments of hospitals say that they have made their contracts sort of so uniform now that people don't need attorneys to negotiate that. I find that very kind of troubling for them to be telling people that, because I think it's there should be some sort of professional oversight and help in those settings. A lot of times doctors don't know what terms are important or what to even ask. And this is perhaps the most important item in the slide here, because really the search for a job should not start with an opportunity that you receive or you hear of or that you are approached with. This should be a months-long process, and this should start with sort of what I tell especially younger docs and a lot of the residents that I lecture to, should start with a period of introspection. Really take a good hard look at where you are at in your life and where you want to be, because it's those long-term goals that need to comport with eventually what that employment agreement says. Otherwise, what are we doing here? You're going to enter yourself into a long-term obligation where you're either miserable or you're not getting to the point or achieving your goals. And that can't be the state of medicine today. And again, I know I'm talking to a lot of experienced doctors, but this is a conversation that I'm having a lot with younger docs because they're itching to take that first job or that first opportunity they get, which I think is selling themselves short. So in that period of introspection, I would urge anybody who is thinking about making a change to speak with obviously their loved ones, because they're in it also. That contract is also theirs. Their attorneys. And again, I would say everybody has sort of like a family member or an uncle who practices law, maybe real estate, but I would definitely urge everyone to get or bring on an attorney who is an expert in healthcare. And any other trusted advisors, any of your mentors who you dealt with in residency, just colleagues who you know are in different physician settings and employment settings that can talk to you about what types of things they encountered that make for a more important discussion when it comes to negotiating your contracts. Are you going to consider compensation to be the most important term? Do you have loans? A lot of doctors now coming out of med school and into residency have hundreds of thousands of dollars in loans. So are they going to forego some of those quality of life provisions for the higher compensation? Again, I think really what the underlying theme needs to be is that negotiation and that ultimate employment agreement and the provisions therein need to comport with your long-term goals, and you need to be honest with yourself as to what those long-term goals are. And like I say here, what you want really is the key. Now, a lot of times when it comes to negotiations, doctors often tell me, well, how much bargaining power do I really even have? These health systems, they employ hundreds of doctors and why do they care? I'm just one of many. Right. And to some extent, they are somewhat correct about that. OK, when it comes to the health systems, and I'm not bad mouthing health systems, but I think you can tell there's probably on my end a little bit of a bias against them. I tend to think that the private employers and the private practices are not better, but just people that I generally tend to support more. But when you're trying to find a job and you're looking to bargain, you want to try to maybe make yourself a little unique, stand out from the crowd here a little bit, because becoming unique in some manner will obviously put you in higher demand, and you'll be able to bargain on a higher level playing field. I can give you an example of that. Just recently, I had a doctor who came up with I guess the idea of creating a particularly new or nuanced area or department in a subspecialty department in a hospital setting. I believe it was a menopause center. Whatever it was, again, it sounded pretty unique, and actually we leveraged that in negotiations, and we're able to get a better deal for this particular doctor because that was something that the health system felt would bring in more patients, and was something that set that that doctor aside from others. And so again, leverage whatever type of unique skill that you have in order to do that. Another important consideration in negotiations is where you want to work. Because you're going to move around. There's nobody generally works in the same setting for their whole entire career. We all know what non-competes are, and we'll talk about that specifically in a little bit. But again, if we're going to in our long-term plan and introspection, if we're going to decide that we want to stay in one particular area, Brooklyn, New York, Staten Island, New York, we don't want to leave that area, then obviously making sure that you enter into arrangements or agreements that have non-competes that won't prohibit that are going to be very important. Other doctors are saying, I'm happy to move to any state, so it becomes less of an issue. But non-competes is going to be a very important issue. So last thing I'll say before we change to the next slide is that in this period of introspection, which should predate an actual negotiation and search, should be a real legitimate search for employment, not just take one or two meetings. Really should be many meetings and many different opportunities looked into, because I can tell you from experience, from speaking to docs who are just miserable in their current setting, it's just not a good place to be in when you take a job simply because it happened to be the first opportunity that you had received. So those are the things that I've heard as far as complaints go, and some things that I would ask you to all consider when negotiating and looking into that. Next slide. So what are the key provisions in an employment agreement? So I have, and I can share this if the members want. I'll share this with Dr. Acharya, and he can send it out to members if they'd like. What a typical employment agreement looks like, although I'm sure that everybody here has seen several different iterations. But what are the key provisions we're going to talk about? Well, number one, an employment agreement will have a commencement date. When does it actually start? And that's important, because if you're in a setting or a current employment setting and you're going to enter into a new agreement, then you're going to want to know when that actual agreement starts, because there might be a lapse or a lag in when you'll actually start, and that's a compensation issue. Of course, your salary and compensation structure, that's going to be something that a lot of doctors are going to look into, and it's going to be extremely important. Now, understand that compensation generally deals with what a base salary would be, but in addition, what type of bonus structure you might be looking at. And those bonus structures are going to be essentially nowadays just simply tied to RVUs, and we'll talk about that. But trying to negotiate what your bonus structure can make or break a deal if your base salary is not up to what you think it should be. A lot of times I had questions about, well, am I making enough? Or is this compensation even something that is appropriate for me, or from someone with my years of experience? And a lot of times, obviously, I cannot answer that because it really comes down to what physicians need in reality, and what they need to pay their bills, what they need to comport with that long-term plan that I had talked about. But there are some databases that you can look at. One, I think the most important of which is called MGMA, which I think a lot of people in this room probably has heard of. We have access to those databases, so you can certainly contact us, and we can give you some insight into that. But generally, what you're looking at is that it's going to be largely contingent upon your specialty and your geographic area. So an internal medicine doc, an IM doc is going to make less than maybe a spine surgeon, but that's also going to be contingent upon where you are. If you're in a rural setting, generally compensation is going to be lower than if you're in Manhattan. So other typical terms are going to be reimbursement for your business expenses, CMEs, license expenses, and so forth. What your general responsibilities are to the actual setting. A lot of times, especially in health systems, they'll say, well, you need to comport with, or you need to read this manual, this protocol that we have. Obviously, make sure you read that beforehand. But those big health systems like Northwell and so forth, they actually have them on their websites. You can actually see them before you even enter into a negotiation, or even approach them with anything. Term and termination. And again, we'll talk about this a little more specifically in a little bit, but term means how long is the term of your contract for? 1 year, 2 years? In the end, does it really even matter? Because as we'll see in a little bit, all contracts can be terminated without any reason or without cause by either side on an amount of days notice, much less than what generally the term is. How often does that agreement renew? How can the agreement be terminated by the physician and also by the hospital? What accounts for cause when an agreement can be terminated for cause? What are some of the clinical responsibilities that you might have? The call duty and schedules. We'll talk about that in a little bit. What your responsibilities are for marketing. Generally in the private practices and smaller practices, you'll be marketing and trying to bring in patients into the practice. What about your professional liability insurance that we'll talk about a little bit as well? Claims made, occurrence policy, tail policy, all these terms I'm sure you've heard, all things that need to be negotiated beforehand. And then, of course, the big one, restrictive covenants, and we'll talk about that in a little bit as well. But restrictive covenants going to be probably, if you've ever had a discussion with an attorney before regarding employment agreements, is going to be something that is going to be of utmost importance. So if you can go to the next slide, I'd appreciate it. So as we said before, the term of the agreement. So a lot of times when you're entering into negotiations with a health system or a private employer, one of the first things they'll ask is, well, how long do you want the term of the agreement to be? And by the way, even the health systems now don't even necessarily give you contracts. They give you these term sheets, which just have sort of blocks in them, one of which is the term of the agreement. As I said before, generally terms will say 1, 2, 3 years, but in the end, it really does not matter because, as we'll see later on, termination is going to be what is most important. So what's the difference? You might ask, why would I have a 3-year or negotiate a 3-year contract if I know that my employer can terminate me on 90 days notice, let's say. Again, we'll talk about that in a little bit. Well, what that means is for the length of a time or the length of a term of the agreement, at least for that amount of time, the provisions and the obligations contained in that agreement can't be changed. Okay. So if you have a compensation structure which says that you're entitled to 500 grand, okay, a year, and that term is 3 years, yeah, they can terminate you before that. But as long as that agreement is in place, that compensation can't deviate from that 500,000. Okay. I generally believe that the longer of a term of a contract, the more it favors the employer, because of what I just indicated before. Those obligations, and especially that compensation, that is baked into that business model of that practice. It's so they generally want to keep that salary static. Okay. Having a shorter term, I think, for that reason also benefits the employee, because if there is an ability to, and if you make yourself unique enough, and you're so important to the practice, that ability to continue to get raises or negotiate higher salaries is going to be much easier when that term is over. Okay, so generally we talk about a minimum 10% increase each year, but that's something that is actually even higher now. Now, I'm still on the prior. Sorry, Isaiah, still on the prior slide. I wanted to talk a little bit about partnership. Now, partnership is something that a lot of the doctors who come to me ask about. This doesn't really apply for health systems. Nobody is saying that you're going to become a partner in a health system. It's just not a thing. But for the smaller practices and the private practices, the promise of a partnership is very important. And there are lots of caveats that come with that. Now, what is the partnership track? A lot of times, younger docs especially will tell me that a private practice has offered them a partnership track. And I often ask them, well, what does that mean exactly? Is that a real partnership, first of all? Or are you just being told that you'll be named partner, or you can go around telling people that you're a partner? Okay, are you actually getting an equity stake in that partnership? Now, for the most part, a true partnership means that you're buying into the system. So, for example, in my law firm, I had to buy in for my equity stake into the law firm. For physicians, it's the same thing. That equity stake can be very significant. Okay, and there are many different ways that a physician can pay that equity stake or pay that buy-in. A lot of times, younger docs with the promise of becoming partners, which again is becoming more and more necessary to keep these younger docs from going to the health systems, to the big health systems. A lot of times what is offered is something called sweat equity, where you sort of work off the payment for the buy-in. You don't actually have to make an affirmative payment out of your pocket. Instead, you're foregoing certain portions of your salary or compensation, or more importantly, your bonuses. Again, I'll only take 50% of my bonuses here, so I can take that other 50% towards that sweat equity, or even 100%. Another important consideration for partnership is doing your due diligence. If you're going to enter into a negotiation with the practice about becoming a partner, and that's going to be part of your agreement, we need to make sure that in your employment agreement, it also says you're entitled to the books. What are the liabilities of that practice? Because again, if a practice has a huge overpayment demand from CMS, or an audit, or a bunch of malpractice actions which are over or above average, that becomes your liability when you enter into that partnership. So that's extremely important to make sure you do your due diligence, just like if you're buying into any other business. Next slide, please. So again, I touched upon before why term is not necessarily as important as termination, because essentially most agreements, if not all, current employment agreements will have provisions which indicate that either side can terminate the agreement despite what the term is on a certain amount of days' notice. Okay, and those generally can be done without cause or with cause. Without cause means that you don't really need a reason. You've essentially become at will, and the employer, and conversely yourself, can terminate the agreement just as long as you give them a certain amount of days notice. Okay, typically that's 30 to 90 days, and this really comes down to comfort level. Generally, for employers, or I'm sorry, employees who I deal with, they kind of feel like, well, if the practice has the ability to terminate me for no reason, I need some time to find something else. So they generally want the 90 days, or even ask me to ask for more than the 90 days. That can backfire though, because if you are terminated based upon 90 days notice, and you happen to be in a setting which is completely miserable and untenable, you're not stuck there for 90 days if you want to be paid for that time. So there's a risk either way. Same thing goes with cause. So generally, there does not need to be any notice if certain triggering events occur, which allow for either side to terminate the agreement without providing that notice, and those are generally sort of borne out in negotiations, but you're gonna see some of the obvious things like that, are you convicted of a felony? Of course, that's not going to happen, but of course, that's something that the practice wants to be able to terminate you for without having to give you notice. Is there a license issue? Has your license been restricted? Okay. Is there a license action? Many times we negotiate that provision because there are many license actions which can be undertaken, which don't necessarily mean that it's actually disciplinary, and we don't feel that that should be or fall under the auspices of a with cause termination. So again, these things are important to consider, but again, there's a cost that comes with termination as well. Okay, again, we'll talk about non-competes, but that termination means that it's going to trigger that non-compete. So again, if you are going to be the one, if the employed physician is going to be the one that's going to terminate, we have to really consider what that non-compete is going to mean. Also, very often, I have doctors who negotiate loan repayment provisions in their agreements, or even sign-on bonuses. I've seen many times where physicians are able to procure a sign-on bonus, ultimately put that money in their pocket, terminate their agreement without cause, and then they get a nice nasty letter from the employer saying, hey, give us back our sign-on bonus because we had an expectation that you would be here for a certain amount of time. That needs to be negotiated beforehand. Same thing with loan repayment. If you're lucky enough to have found a position where the employer is willing to pay back some of that, or some or all of that medical school loan that you have, we need to make sure that doesn't sort of go away or even get clawed back if you terminate. So next slide, please. So again, we talked about a little bit before about compensation and how to make sure that you're being compensated properly. This is really the part of the negotiation that those doctors who were sort of on the fence about having attorney involved will ultimately change course and say, you know what, Dave, or healthcare attorney, please, I want you to get involved here, because for whatever reason, this makes doctors the most uncomfortable. Doesn't bother me the least bit. I will obviously negotiate and advocate for anybody who asks for whatever compensation they need within reason. And there are certain databases, which I had mentioned before, which you can research that. And again, there's nothing like asking colleagues. Hopefully, we're in a place now where people are open about their what they're making. But again, we don't need to even ask those questions because we have MGMA and other databases which we can touch upon to find out what generally your specialty and what in your geographic location are making. We also have to consider what bonuses and what bonus structures are available to us. There's numerous options, most of which will fall upon nowadays, which will fall upon RVUs, which again we'll talk about in just a couple minutes. RVUs is becoming increasingly important. Nobody really knows what RVUs are. I'll try my best to explain what they are later, but it's a very sort of convoluted, metric that unfortunately is never really going to give a firm understanding when you enter into an arrangement as to what it means for your bonus structure. And what I've seen nowadays is health systems preying upon that, which is something that I feel is unfortunate. Whereas we've had incentive bonuses on an upward scale, for example, a health system or an employer will say, if you reach a certain percentage RVU or a certain amount of RVU, we will pay you this amount of bonus over and above your base salary. Well, we've now seen our health systems incorporating a reduction where if you fall below a certain metric RVU, they will actually reduce your base salary. I really hate these provisions and really do whatever I can to convince a doctor not to enter into an agreement that contains provisions like this. But you'll see more and more that these are becoming non-negotiable, especially with the big health systems, unfortunately. Next slide, please. So again, what are RVUs? Relative value units. It's a standardized metric utilized by healthcare providers and employers in order to assess a particular financial compensation to a particular service. That's a really long-winded way of saying what they value a service being. And there's many different ways to come up with that. There's different components to an RVU. Let's say there's your physician work, which is known as the WRVU. So you'll see the W a lot of times in your agreements. The practice expense, which is the PERVU, and the malpractice RVU, which is the little m RVU. I don't have that up on the slide here, but that's the different components of what an RVU is. And what they're basically saying there is that there are certain services that you're expected to perform, certain procedures and services that you'll perform for patients, and that's allotted a certain, in their minds, a certain reimbursement. Okay, and they want to cut out some expenses. So what the expenses are to the practice and what generally their malpractice costs are. Although I would say that the malpractice RVU is something that I think should be less of a concern to an employer since we all have insurance. But ultimately, that total RVU is going to be what is going to serve as your metric for coming up with your bonus structure. Now, a lot of this is impossible, especially for younger docs, to understand and negotiate on their own. And this is really generally 50% of the conversations I have with doctors when we talk about negotiating agreements is about RVUs and meeting RVU targets. I get the question all the time, well, will I be able to meet this RVU target? I can't answer that question. It really comes down to what your motivation is and generally what you are able to find out about what a typical day is in this particular practice. And we'll talk about maybe in a couple of slides here about how you can ascertain things like that. But it's really going to become incumbent upon doctors looking at opportunities to speak with their colleagues and do research regarding what these RVUs mean. I fully understand that talking about RVUs in the way that I am in a really broad sense probably doesn't make a lot or perfect sense, and I fully understand that. I'd urge anybody to, if you have more questions, ask me either today or later on. Please feel free to reach out to me about RVUs. Next slide. So I touched upon before what I think is the most important consideration, and that's going to be your quality of life. Okay, and that generally will mean what your work hours are, what leave you have. Generally vacation. Can you take PTO, maternity and paternity leave? What support you get for certain expenses. I mean, you have to take CMEs. That's going to mean you will be taking those CMEs during what would normally be work hours. Okay, are they going to support that? Are they going to pay for that for you? and generally opportunities for growth otherwise. And that means being a member of the NYACP, professional associations like the different medical societies in New York. I would believe or hope that employers and health systems would believe that they would want their employees to be part of organized medicine, and that should be set forth in your agreements and should be supported. Another thing that you might want to consider a quality of life consideration is what do you want to do outside of the actual employment obligations. There's something called moonlighting, which you might have heard of, and that basically means that, well, yeah, I get it. I'm entering into an employment agreement with you, health system, private employer, but I do want to work in or perform services in this underserved area. It might even be for some compensation, but I want to be able to do that. That is what what I thought I was going to do when I was in medical school anyway. Those things are called moonlighting. Are you going to be allowed to work outside of the employment agreement setting? Again, a lot of times, generally employers are not going to have an issue with that, but they're going to want to know what it is. So they're going to impose, maybe when we negotiate correctly, that they might say, okay, fine, you're able to moonlight, but just make sure that you tell us beforehand so we can approve of that. Feel that's reasonable, but something you need to know about before before you enter into the arrangement. Next slide. Okay, so restrictive covenants, generally, like I said before, one of the most important things you're ever going to negotiate when you enter into an employment agreement are these restrictions. Restrictive covenants are going to be non-competes and non-solicitations, generally. Okay, you also have NDAs in there as well. But non-compete means, or for the most part, in these employment agreements, means that for a certain amount of time, definitely during the term of the agreement, but for a certain amount of time after separation, whether it be by termination or whatever reason, you cannot compete with your employer. With the way that these contracts are generally written, this can be a career killer. Now, there's a trend now. Courts are loath to enforce them, but they will in New York. A lot of times they will change the terms of a restrictive covenant or non-compete to limit the scope or make them more reasonable. There are some states which have completely outlawed non-competes, and I can tell you with 100% certainty that will be the case in New York someday. But for right now, non-competes are a thing. What we want to do is make sure that the non-compete in the agreement is limited in scope as much as possible. So what we generally try to negotiate is the temporal portion of the scope of that agreement. So a lot of times we'll get an agreement back that says that this non-compete will last for 3 years. And so we want to reduce it to 1 year, let's say. A lot of times it'll say that you cannot, sorry. Hello? Can everybody hear me?
Yeah, I can hear you.
Are you seeing the, I'm sorry, 1 second. I just got a little bit of an error message. Okay.
Yeah,
so,
we hear you fine.
Okay, sorry about that. So a lot of times you'll see a restrictive covenant which will incorporate a geographic location a term as well, which will say that for 1 or 2 miles or 3 miles, 10 miles, you can't compete in that geographic location. Again, it could be a career killer. And what we're trying to do is negotiate that geographic location down in radius as well. That really is largely contingent upon where you are practicing. So if you're in New York City, even a 1 mile radius is not reasonable. 1 mile can generally incorporate the whole island. So we generally talk about a system of blocks there for restrictive covenants there. But for upstate, let's say, where it's where you don't have a doctor's office on every corner, you talk in miles generally. Now, a couple of things you want to make sure when you're negotiating these non-competes is that if the employer terminates your employment without cause, then you should negotiate in your agreement beforehand that the non-compete should not be enforceable, right? That is something that we do as a matter of course now, but it wasn't something that doctors did typically in the past. So again, if the employer is going to terminate you, then we feel it's unreasonable to be subject to a non-compete thereafter. A lot of times, breaking a non-compete becomes strategic if you're looking to enter into an arrangement with a more favorable employment setting. But I would urge anybody who's even thinking about that to contact healthcare attorneys as well, because we've been in obviously court where employers are looking to enforce a non-compete. A lot of times those agreements will have what are called liquidated damages, calling for hundreds of thousands of dollars in payments and penalties. So we don't want that at all, obviously. So again, non-competes are a thing. Right now they're staying, but we need to limit those in scope as much as possible. Now, for health systems or for doctors who are working in health systems, this is all the more important because typically the health system employment agreement now will contain non-competes, which will say for a period of 1 year, you cannot work in any setting which is affiliated with all of the other health systems in the area. So listen, we only have 4 or 5 big health systems, or however many they are, just a few or a handful. If we're working in the health systems like that, and a lot of people are now, it's really difficult to move on from one setting to another if we're going to be prohibited from entering into arrangements with the other big health systems. So really think carefully about allowing yourself to be subject to a non-compete like that, because again, there's nothing you can do if that health system wants to enforce 1 or 2 years of you not being able to work and sitting around not being able to work in a health system like that. Okay, I got the 5-minute note here, but one other consideration, if we go to the next slide, is medical malpractice. Just very quickly, obviously there is a difference between occurrence-based policies and claims made. I'm sure everybody here has heard of those. Occurrence-based policies, they provide you coverage for incidents that occurred during the policy period, regardless of when it's claimed or filed. But that's the, for lack of a better term, that's the better insurance to have. So you basically want to negotiate for occurrence-based rather than claims made, because after leaving a particular setting, if you have claims made and someone sues you for a particular service that was provided while you were at that employer, you are suddenly without insurance. Okay, claims made policy is not going to cover that. What that means is you're going to have to, after leaving that setting, you're going to have to purchase what's called a tail. Those can be very expensive. I've had clients who have not purchased tails because of the expense and have been sued, and are paying for malpractice legal fees and also paying awards out of pocket because they weren't properly insured. So again, a key consideration is to make sure the best you can to obtain an occurrence policy, and possibly get your current or your prospective employer to pay for a tail if that's something you need. Next slide. Very quickly, because I only have a couple minutes here. It's very important to do your due diligence. Find out the most you can about a prospective employer. There are many databases you can look at. You can go to the Department of Health OPMC website, and that will have reports of any disciplines that your prospective employer or people at that practice might have been subject to. Go to the Medicare exclusion list, the OMIG exclusion list. Ask around, ask different current or even former employees of a private practice, what their experience was like, because that information is going to be invaluable. And again, if anybody needs some information about how to find those databases, certainly reach out to me, and I'll certainly be happy to send that to you. But with only a couple of minutes here, I think the next slide is my question slide. So if anybody, again, that was a very sort of brief and basic overview of your employment agreements. And if anybody has any questions, I'm happy to take them now.
I think we have, thank you. I appreciate you for such a great presentation, David. Thank you a lot. I think we have, just in respect to everybody's schedule, I think we have time for about 2 or 3 questions for David. I'm also gonna launch the poll for like the end of the session. So if you guys could take a few seconds to just fill the poll out, that would be greatly appreciated as well. So can we fill the first question for Mr. Vozza?
David, uh, what would normally be somebody like you would charge for a contract review as opposed to negotiations?
Sure. So, as Dr. Chari, as you might know, I've talked about this plenty of times before. I really feel like contract negotiations have become so streamlined that unless you're getting a really particularly unique contract for whatever reason, these negotiations and these reviews should not run, I hate to even say over $2,000. I mean, generally we're talking $1,000. Okay. And that's because I generally take a lot of time trying to go through every single provision and explaining to the doctor. But again, I've made this pretty efficient. So I think a very cost-effective way of making sure that you don't end up into a miserable employment setting. So any other questions?
I think we have a question from Dr. Simon.
Yeah, David, thank you. I actually thought you did a really terrific job because you took a very expansive charge that we had for you tonight, and I think tried to hit everything in a pretty concise way. My question is really whether you agree with what I'm about to suggest. So, I've been a residency program director for over 20 years. It's very common. I very, very commonly have residents who are about to graduate or recently graduated come to me and ask me about contracts. And I've done this, and I'm not a lawyer in any way, shape, or form, but I've, entered into contracts a few times. And I always tell them two things. The first thing I tell them, which I know you're not going to argue with at all, is get a lawyer. No matter how simple you think it is, no matter how straightforward, no matter what you've been told, this should be reviewed by a lawyer with experience in healthcare. The second thing, though, is, and tell me if you agree. I was told this, and I experienced it. The most common thing that I hear from my residents is that the employers, particularly if they're health systems, say to them, look, this is our standard contract. This is the way we do it. This is what everybody gets. We're not changing it. And my advice to them is always baloney. Everything is negotiable. That's why it's a contract, because it's negotiable. And if you have things that you're concerned about, you can always ask about it and ask for changes. Do you agree with that?
I certainly agree with what you're saying. I've heard the same thing, and a lot of times when doctors come to me, they kind of called me only because they sort of had a notion that maybe I should give a 2-minute phone call to a lawyer, and then when I tell them, hey, you can negotiate some of these terms, they're sort of taken aback. It's a somewhat of a process to convince them that they have value. That's what I said, what I indicated before. And that is in large part because exactly what I had said before. I've heard attorneys at in-house attorneys at these health systems say the same exact thing. I think they feel like they're doing a favor when I think it should be viewed the other way around. But certainly, I do agree, and I've heard the same sentiment.
Thank you.
And we have time for one more question.
Yeah. Hi, David. My question is more related to your introductory statements, which was not about the contract of sex, but about business that you and I know, I've worked on before, where Medicare or an insurance company tries to recoup money. Now, you mentioned, okay, Medicare will send you the letter, and they may come after you if you don't take corrective action. What if you as a physician believe that there was no corrective action to take and you're doing the right thing? Is there any way out of that?
Yeah, there is. So what I think that Medicare wants to see is that you didn't do I hate to say it like this, but you didn't do nothing. that you at least did something. So a corrective action plan, to me, that we would draft in a setting like that is to acknowledge the fact that you received these educational letters, that as a practice you counseled or sought counsel with maybe a biller, a coder, an attorney, and came up with a certain plan, implement some sort of remedial measure, which might even be something minor, or indicate that after review you have found that the practice is not deficient in that manner. At least you can point to a proactive measure. So when CMS comes knocking, you can at least say you implemented something, you did something, right? What they're hanging their hat on, it's not even CMS, it's the contractors, because the contractors are incentivized to find ways to find money, and you and I have spoken about this before. It's a sort of broken system. So why give them even a leg to stand on? I hear what you're saying. A lot of times the CMS and these educational letters are kind of nonsense, but we don't want to give them a reason to come back and say you didn't do anything. So I certainly feel like everybody should take those seriously.
Thank you. Dr. Seminar, do you have one final question?
John Mace.
John Mace. Sorry about that, Dr. Mace.
That's quite all right. We're a tag team. So I just have a question. Is it better to be a direct employee of a hospital than to be contracted in this way? Because if they tried to lay you off, right, they would have to provide you with some sort of compensation if you're laid off. And aren't you have better employment rules that protect you than doing a contract?
So I hope maybe I wasn't clear. I was talking about employed and being employed by the hospital, those agreements. So I think
I'm sorry. It was clear that employed, but if you were directly employed by the hospital without a contract, right? You just they had an FTE and you applied for that position and you were directly employed by the contract. It seems to me when it comes to being let go, because sometimes hospitals think that doctors and PAs and nurse practitioners are interchangeable, they would have to give you some sort of severance. Do you negotiate severance into the agreements?
I don't think health systems are paying out severances, but for a long time there was a lot of resistance to this. Sort of, it was more of a sovereignty issue. I think doctors want to not necessarily be sort of part of a corporate structure. I don't think that hospital systems or health systems are treating. And again, I really don't want to. I'm not really bad mouthing hospitals. I'm just telling you what my experience has been. I don't think they're treating hospitalists or direct employed physicians any better. So I don't think that that's really a consideration that I've seen a lot of with the clients and doctors who have called me.
So they can treat a doctor differently than they could a vice president of something at a hospital, and employment law allows that.
Oh, I'm sure. If they want you out, I'm not exactly sure what you mean by vice president, but I've certainly had many clients who have been or the vice president or the administrator of some committee who have been terminated, just like I've seen them an employed physician terminated as well.
Okay. All right. Thank you.
Yeah.
Thank you again, David. It was very greatly appreciated. Great presentation. I would like to thank everybody for joining us tonight.